My name is Russell Dunlap, and I'm a partner at Taylor English Duma in the Intellectual Property Group. Today, I'd like to talk a little bit about what is a patent. So a patent is a piece of property, just like any others that can be bought and sold. And it is basically a document or certificate that you receive that allows you to be the only person to make, use, sell, or import an invention. Now, it's country by country, so let's just talk about the United States at first. A patent in the US allows you to be the only person to make, use, or sell your invention or import it from outside the country into the US. It is a sword, it's not a shield, and what that means is it can be used to stop people. You can't use it to protect yourself, but you can use it to stop people from making, using, or selling an invention or importing it. There are two main types of patents in the United States. There's utility patents and there are design patents. A utility patent is a patent that covers a functional invention, something that provides some sort of benefit, some sort of useful benefit, whether it be a product, a consumer good or industrial product that provides some benefit to its user, or it could be a process, maybe a method of manufacturing or a method of operating a piece of equipment or something like that. Both of those are patentable potentially as utility patents. A design patent covers what something looks like. A consumer good, especially like a shoe or a hat or any other product that's value comes from what it looks like. Something unique about it, that its look, its ornamentality provides value, and you'd want to be the only person to sell a product that looks like that. And you can file for both utility and design patents on the same product as well. I often recommend that for consumer goods because there's value in the functional benefit it provides and there's value in how it looks. So a patent also typically has a description and drawings of the invention, and it also has what are called claims. Claims are what you use to enforce the patent. I claim a product or a method comprising X, Y, and Z parts or steps. Or in the case of design patents, I claim what is shown in these drawings, just front, back, left, right, top, bottom perspective view of this product. That's your claim, and that's what you use to enforce the patent. If somebody, a competitor, makes a product, sells a product that has those X, Y, and Z components, and you have an issued patent, then that's where you would either send them a cease and desist letter, or you could go to a court and say, Judge, this company is making a product that has X, Y, and Z. My patent claims X, Y, and Z, therefore they're infringing my patent. And then you would go through the legal process to prove that they are infringing your patent. And if you win that process, then you can have them pay damages or stop making it or selling it or importing it. It can be done in a variety of ways. The process to obtain a patent is you basically put together a patent application and you file it with the country's Patent and Trademark Office. In the United States, that is the United States Patent and Trademark Office. You file your patent application and then it is assigned to what is called a patent examiner, a person that would review the application to see if your invention is something that is patentable. Is it a new invention? Has nobody come up with the idea before? Is it not something that's obvious over what's already out there? And the patent office, the patent examiner, will issue what is called an office action. It's just a communication or a letter that says, I've reviewed your patent application and these claims I believe are allowable or not allowable, and here's why. At that point, you would start a negotiation with the patent examiner, whether it be kind of tweaking the claims or maybe making arguments that, no, you're interpreting this wrong, examiner, here's why these claims are allowable, here's why my patent application is allowable. And once you come to an agreement with that examiner, then the patent examiner would issue what's called a notice of allowance. You pay an issue fee, and now you have a issued patent that you can use to enforce against people to stop them, like I said, from making, using, selling, or importing a product that infringes that patent. The utility patent, they last 20 years from the date that you file your patent application. A design patent lasts 15 years from the date that the patent issues. And during that time, that's the time period that you have to prevent people from making, using, selling, infringing your patent. So the patent process is a long and complicated process, or it can be, and can be expensive. So it is highly advisable to work with an attorney from the very beginning, because it is a highly technical process and there are a lot of missteps that can be made that can really hurt your the patent that you get, or maybe even affect your ability to even get a patent in the first place. Especially if you want to start showing off your invention, if you want to start telling people about it, talking to investors, talking to business partners, talking to manufacturers that can make it for you. Those steps you take can affect your ability to get a patent. And it's highly advisable to get a patent attorney involved early in the process so they can make sure that you are protecting your invention as efficiently as possible and as broadly as possible. For example, if you publicly disclose your invention, let's say you show it off at a trade show and you don't have a patent application on file, that could affect your ability to get patents outside the US especially. And depending on how long it is between that public disclosure and when you file your patent application, you could lose rights in the US as well. So when you're thinking about showing off your new invention, you really need to take into consideration whether or not you've taken the necessary steps to protect it first, and try to get something done early in the process and make sure you consult with an attorney early in the process. So thank you for taking the time to watch this. I hope this was helpful, and good luck on your patent journey.